Navy leadership believed in the impregnability of Pearl Harbor, and so they discounted all information, discounted all intelligence regarding movements by the Japanese Navy. And then it's also been well cited, confirmation bias has been well cited in regards to the American invasion of Iraq in 2003 with the Bush administration. The last one is a more recent phenomenon. So social network analysis, what the argument here, or the analogy is that you can look at a society as a network of interactions between all the people in the society. And the question is, well, what's the nature of interactions between the people in the society? Okay, is it something that's inclusive and tolerant of dissent, or is a society intolerant? Okay, so what the research finds out, and this is coming from Stern and Adams and Himmelboim in particular, is that they point out that when you have social networks that are intolerant and exclude dissent, they tend to lack an ability to exercise critical analysis. They seem to be unwilling to go ahead and process information that seems to present alternative viewpoints. And for societies in general, this poses a danger in the sense that you tend to get polarization in political discourse, and you get a hardening of views. In societies that function, or societies that encompass homophilic networks, are societies in which there's very little compromise, all right? And in effect, you end up getting what James Madison and Alexander Hamilton predicted. You get the result of faction, okay, an erosion of cohesion in society. Right. Now, I wanted to jump to the question of civil disobedience as a particular form of dissent. And the reason I want to do this is that civil disobedience represents an extreme form of dissent. And here's the reason why. When you look at the definitions of civil disobedience, and I draw upon historical figures like Henry David Thoreau, Leo Tolstoy, Mahatma Gandhi, Martin Luther King Jr., there are certain common elements in what they consider to be civil disobedience. And so among the common elements are, number one, that civil disobedience involves a violation of the law. Okay? Alarm bells should be going off in your head right now. All right? Number two, that civil disobedience is done in accordance with personal conscience. Okay? Again, alarm bells should be going off in your head right now. And then the third is that civil disobedience is nonviolent. Right? Now you can see that if you're a leader of a government, that you are going to have concerns about this. All right? First thing is that if anything that involves a violation of the law, okay, implies that there's an offense against the state, because the state articulates the law, so therefore a violation of the law is a violation of the state. It's an offense against state power. All right? So therefore a threat to social order. All right? Regarding the notion of idea that you're violating the law in accord with personal conscience, okay, the implication here is that by calling upon people to exercise judgment in accord with some normative basis, in accord with their own morality, that means you're asking people to look to a source of authority that's above the government. Okay, inherently problematic if you're a government leader. You're going to see that as a threat to, again, a threat to the social order. All right. So what I did here was I listed what I think to be our defenses against these kinds of arguments, and to sort of like thwart these lines of reasoning. And what I assert is that if you look at the definition of civil disobedience, particularly when you look at Thoreau, Tolstoy, Gandhi, King, and you read what they're writing, what they argue is that they're asking for a violation of the law. Okay? They're talking about unjust laws. Nowhere in that discussion are they talking about unjust governments. Nowhere are they talking about actions against the state. All right? So generally, civil disobedience is concerned about the legitimacy of law, not it accepts the legitimacy of the state. All right? Regarding the question of morality, again, civil disobedience is asking for morality that judges the justness of a law. Okay? It's not asking for morality that judges the state. All right? So the implication here, at least when you look at Thoreau, Tolstoy, Gandhi, King, is that when we talk about civil disobedience, we're looking at situations where it's a very precise, very surgical political expression, right? And it does not seek to threaten the state, does not seek to threaten the social order. What it's really seeking is to question the law, right? And it's seeking to question the laws in situations where there is a dysfunction in decision-making, where there is homophilia, where there is groupthink, okay, where there is confirmation bias. Civil disobedience is trying to be an avenue around those kinds of problems. All right. The element of nonviolence, I think, is by definition not a threat to the state. All right? Anyone who espouses nonviolence is basically saying that they're trying to avoid or control the escalation of tensions involved with protest, and above all, they're trying to respect the rights of others. All right? So they're trying to prevent the violations of rights. So in other words, they're trying to maintain social order. All right. So let me return now to the Federalists versus the Anti-Federalists. And, you know, we talk about, well, if we're going to accept civil disobedience, then how do we accommodate civil disobedience? How is it that we maintain stability if we're going to go ahead and allow people to engage in these expressions of civil disobedience? And so this is where I reference the U.S. Legal history in regards to First Amendment freedoms. So for those of you who don't know, First Amendment, just as a reminder, deals with things like the rights to free speech, the rights to assembly, and you can sort of construct the right to privacy. And this is where I call upon you, those of you who are taking notes, because I do see some of you still taking notes right now, that you want to refer back to the comments I made about the Federalists versus the Anti-Federalists. You can sort of see the themes of their debate play out in U.S. legal history now. So the way the United States legal system deals with the question of civil disobedience is that they start off with the Madisonian position, that there is a presumption that there are certain kinds of liberties for which the government cannot take action. All right? And then following the Madisonian Compromise, the U.S. legal position is that the government can constrain civil liberties, but it has to pass certain requirements. It has to pass certain tests. So what are these tests? Well, it depends on the case. So the first case is if you have a law that attempts to constrain the time that a political expression occurs, the place where political expression occurs, or the manner in which the political expression is done. All right? In this situation, what the law says is that the U.S. government can go ahead and control dissent, can control civil disobedience, if it serves a very narrow government interest, okay? If that government action is very narrowly tailored to the particular kind of expression in terms of time, place, and manner, and it is viewpoint neutral. So in other words, the government is not trying to control the viewpoints of the person engaged in speech. The second category is what they call content-based restrictions. So here, this is where you get to the question is, can the government control the kind of political viewpoints that are being expressed? And the answer here, again, following the Madisonian Compromise, is yes, but under certain conditions. So what are those conditions? There has to be a compelling government interest, right? And if the government takes an action against a particular kind of political viewpoint, it has to be narrowly tailored to limit speech only to the extent necessary to fulfill the compelling government interest, right? And the government action has to be the least restrictive means available, all right? Third category, there are certain kinds of speech for which public policy deems there is no protection. So this is where we talk about stuff like inciting imminent lawless action, obscenity, all right? Things that are like inflammatory language that are likely to arouse a hostile reaction from the person you're speaking to. And so since I have a few minutes of time, I want to go through a couple of examples here. So I have the cases. And Grayned versus City of Rockford, 1972, all right? So in this situation, it was a high school. So for you, it would be a secondary school. And there was a city that had a law. And the law basically said that you cannot have political protests outside a high school, in other words, outside a secondary school, during school hours that disrupts student attention, all right? And then what occurred was that you had Grayned, who was the leader of a protest group that wanted to support desegregation. So he led a group of people outside a high school in Rockford that called for and argued for desegregation, and he was arrested. So he sued as a violation of his right to free speech. And who do you think the court sided with? The government or the protester? All right. The court sided with the government. And here was the argument. Here's the reason why. The court said that the city of Rockford had articulated a sufficiently specific time, place, manner restriction. The ordinance specified the time when protest was allowed. Okay, it had to be protest could not occur during school hours, which meant that it had to be outside of school hours. The city ordinance specified the place. Okay, so in other words, if the protest was going to occur, it had to occur outside of the school, not inside. And then third, the ordinance specified the manner of protest that was allowed. So in other words, that the ordinance said that the protest could not disrupt student attention during school hours. All right. All right. Second example was New York Times versus the United States. Okay, in 1971, what occurred here, there was a situation where the New York Times reporters had uncovered Pentagon papers, okay, that basically detailed or showed how the U.S. military was escalating U.S. military activities in Vietnam without public knowledge and without consulting the citizen government, without consulting Congress. And the New York Times was planning to go ahead and release 500 pages of this to the public. So this was essentially WikiLeaks before there was WikiLeaks, right? And the Pentagon or the U.S. military sued to stop this. And the court in this case sided with, okay, the New York Times. And what the court argued here was that the U.S. military had argued that there was a reason to suppress publication of these documents because of national security. And the court said, yes, we accept that argument. Right? It is a compelling interest to maintain national security. Right? But what the court had a problem with was that the government action was not limited. It was broad. Okay? The government was attempting to suppress all documents that had been obtained by the New York Times reporters. It was attempting to suppress the release of any information regarding U.S. military U.S. military leadership decisions about the troops in Vietnam. Right? On that, the court said that was insufficient. The government could not do that. All right. Okay. So that concludes my talk today, and I hope it gives you something to sort of think about and gives you some food for thought, and you can sort of relate it to your own context and make some decisions as to how you think and what you think is the appropriate balance between stability versus human rights. All right. Thank you.